Think a minor traffic stop can't lead to a full-blown search of your car? Think again. Let's talk about your rights and how to protect them. Hi, I'm Marc Lopez, former prosecutor turned defender of the people. Let's talk about the Fourth Amendment and your automobile. The general rule in the United States of America is that a search warrant must be signed by the judge in order for that search to be valid. That goes back to Arizona v. Gant. It has to be signed by the judge. A warrant is necessary for police, state actors to search your belongings, including your car. Now, the fine print is a search warrant needs to be signed by a judge in order for a search to be valid, unless there's some exceptions. So let's keep talking about that. The biggest exception to a search warrant requirement is a search with the consent of the accused is 100% allowed. So the biggest exception is if the accused gives consent to the police to search their belongings, including a car. And if a person consents, they can't complain about it later. That's the Bustamante case. That is clear under United States constitutional law. Consent is 100% an exception to the signed warrant requirement. Now, the corollary of that is a person can absolutely refuse to consent to a search of their property, including their car. That's Bumper v. North Carolina. And this consent needs to be consensual. It can't have 5 or 6 officers all surrounding a person in their car saying, are you going to let us search? Hey, I'm just going to get a warrant if you don't consent. They can't just do this show of force or, flat out lie. They'll just get a warrant anyway. So the consent has to be voluntary. The consent has to be consensual. It has to be real. It can't just be an illusion. Oh, they said they consent. Or the officer tries to trick some. Officer going to try to trick you to consent because it's so much easier and surefire than getting a warrant. But consent has to be real, has to be consensual. It can't be given under duress. So the case law states the validity of consent hinges on being freely and voluntarily given and not the result of duress, coercion, or express or implied. And then the state has the burden of proving that the consent of a warrantless search was in fact voluntarily given. And so once they don't have a warrant, it's back on the state to say, hey, here's one of the reasons why a search warrant is not necessary. So when the police want to search a vehicle, even if the police have that person absolutely nailed down and they're going to be arrested, the car's going to be impounded, the police are still going to try to get consent to search that vehicle. Even though they can maybe get search incident to arrest, they can do an inventory search, other things we'll talk about, their police are still going to try to get consent because they know if a person gives consent, they can't complain about it later, or they can complain about it, but it's an uphill battle. Especially if the consent is voluntarily or freely given, the officer isn't making any threats. But officers can imply, they can make some white lies. Hey, it'll go easier for you. Hey, if you consent, don't make me work so hard. I'll put a good word in for you. Hey, listen, it'll look a lot better for you with the judge or the prosecutor if you just give me consent for this. Because they don't want to have to get a warrant. They don't want defense attorneys to have extra avenues of attack. Well, hey, it was incident to arrest, but you went beyond that. Hey, it was inventory search, but you didn't follow the guidelines. You didn't do all the things you were supposed to make this an inventory search. There are so many things that defense attorneys can attack that, unfortunately, if the person gives consent, just kind of go away and smoke. And it sucks when you see the consent to a search in there. We'll read it, then watch the body cams, and we just see So don't consent. And what you can say is, I do not consent to a search. Officers may get mad at you, and that's okay. You're making this a lot harder. This is not going to look good for you. Only a guilty person wouldn't let me search their vehicle. Let them get upset. Let their body cam record all of that. You remain cool as a cucumber. Thank you, sir. I do not consent to a search. So, by not consenting, you reserve the ability for your attorney to fight any type of search they ultimately do on that vehicle, or even you. And it just makes everything so much better for you. So, I do not consent to a search. Magical words, officers are going to get mad. Now, even if a person says, I do not consent to a search, there are some instances where an officer is going to be able to search that vehicle. Let's talk about those pretty quickly here. The first way they might search your car, even if you do not consent, is the automobile exception. So let's talk about that. In order to talk about that, we have to understand probable cause. The Supreme Court has consistently held that probable cause exists when the facts and circumstances within the officer's knowledge and which they have reasonably trustworthy information are sufficient in themselves to warrant a man of reasonable caution in the belief that offense has been or is being committed and the person or property was involved in a crime. That's the Patel case. And most importantly, probable cause is not a precise quantum of evidence. Rather, the relevant question is whether there was a substantial probability, something more than bare suspicion, that the person or property was involved in a crime. It's not a hunch. It's not an officer being like, ugh. But at the same time, you can't quantify it and say, here's the exact definition. It's case by case. Some of the key aspects of probable cause, it's a mixed question of law and fact. It's determined on a case by case basis using common sense, not mathematical precision. It requires only a fair probability of criminal activity, not a prima facie showing. So I tell people, imagine a human being is a measuring tape and the top of the human being is absolute certainty. The foot is like no certainty. We have no idea. You know, reasonable suspicion is like the ankle, but to arrest someone, probable cause, that's like a kneecap. That's not a lot of evidence. Take someone's money in civil court, it's about halfway. But probable cause to arrest, put someone on trial is a lot less than halfway, more likely than not. Keep that in mind. So understanding probable cause brings us to the automobile exception. Basically, automobile exception allows police to search a vehicle without a warrant if they have probable cause to believe it contains evidence of a crime. That is Carroll v. United States, a 1925 case. And the justification is vehicles are mobile, so waiting for a warrant could result in evidence being moved or destroyed. And the court reasoned that the mobility of vehicles means the evidence could be quickly moved or destroyed if officers are required to obtain a warrant first. That's still a law in the United States, but that's kind of ridiculous. Most officers are going to wait by that car and they're going to not let someone take stuff out of it and they're going to get a warrant and they're not going to let someone just drive away. So that may have been necessary back in the day, but it's 2025 when I'm filming this and that's not the reality anymore, but that's still the law, automobile exception in action. Well, smelling like marijuana, where states where marijuana is still illegal. Well, guess what? Many states, including Indiana, treat that as if everyone in the car is under arrest and they get to search their car. Seeing drugs in plain view in a car, I mean marijuana or other drugs, again, that's problematic. That's going to be the automobile exception. Hearing incriminating statements between driver and passengers. If a canine alerts, well, that's going to be problematic too, and it's going to get searched. So that's the automobile exception. Even if a person says, I do not consent, the officer still may be able to execute a consent with the automobile exception. Now, the next exception to a warrant requirement is inventory search. And inventory search occurs when police have impounded or towed a car. They inventory its contents. And the purpose of an inventory search, at least what the officers say, is to protect the owner's property, protect police from claims of lost or stolen items, and protect police from potential danger. All that said, they're looking for things to incriminate you. And this is allowed. South Dakota v. Opperman and the U.S. Supreme Court in 1976 and other cases after that said, hey, this is A-OK. They have to follow procedures. It has to be a written department policy, and then they have to actually follow that policy. Some of the police agencies I see have a checklist, and the officers actually check off, did this, did this, did this, did this. And then the reality is, as long as they are doing it pursuant to an inventory search, they impounded or towed the car, and they're following the written policy, evidence that's found during the inventory search can be used against you, even if that wasn't what they stopped you for. So they stopped you for drugs and they find a gun in the passenger side. Well, they didn't know about the gun until the inventory search. Guess what? They can charge you with the drugs and the gun. And in states where there's a firearm enhancement, well, it can be problematic too. So keep that in mind. Now, we talked a little bit about canine search if they alert positive. Rodriguez v. U.S., they cannot prolong the stop to get a canine there. Now, if a canine, if you're unlucky enough to have a canine in the car that pulled you over, that officer can walk around. And if officer is talking to you and getting the bare information, name, ID, what's going on, where you're coming from, and a canine officer arrives, they're allowed to have that canine walk around the vehicle. And again, that could alert and create an automobile exception. So keep that in mind. Even if you say, I do not consent to a search, there are situations where police are going to be able to search that car. But it's still better for you to say, I do not consent, because it allows attorneys like myself more ammunition to fight searches in court. If you feel like officers are taking advantage of you, I cannot stress this enough. Do not fight them. Do not act like a fool. Cameras are recording. You can definitely say, am I free to leave? You're not free to leave. I'm searching your car. I do not consent to a search. I plead the fifth. I want a lawyer. Those should be the only four things you say. Your car, if you stop by a police officer, they'll get you out of most trouble. And at least if you continue to get in trouble, you give your attorney a fighting chance in court. So, if you have any questions about this, give me a call, 317-632-3642. Remember, you have rights. And if you don't stand up for them, then what's the point? These rights are yours, and I believe in them, all my heart and soul. But if you don't stand up for your rights, if good, God-fearing Americans do not stand up for their rights, there's no purpose in them, and they're going to be abused and lost. If you have any questions about Fourth Amendment, give me a call, 317-632-3642. Love to talk about your rights all day.